630 South Arville. From the beginning, this superintendent search has been very badly handled. I think that the timeline that it started in, indicating that the school board wasn't really looking and planning ahead for what Walt was planning and coordinating with him, set us off on the wrong foot in terms of the timeline. Since that point in time, the public has spoken. You had a large petition with thousands of signatures on it, putting Mrs. Janison's husband, employer, on the list of candidates for the interim superintendent. Later on, he submitted a letter to the school board, or actually to Terry personally, with a rather familiar Dear Terry as the introduction, putting her in a conflict of interest, which is fairly clearly enunciated in the NRS. On doing a Google search in the NRS, the first thing I came upon was an item from a attorney writing to another school board that said, when you read the section of the NRS that addresses disclosure and recusing, it defies simplification. Defies simplification means you can read it and understand it as simply as it can possibly be. And what we're seeing at this point in time, whenever an occurrence of this issue comes up, is a failure to disclose and a failure to recuse. Now, for instance, when the decision was made to ignore Andreas Magoza's petition that he brought to the school board, that was a decision even though it didn't take a board vote, and in my opinion, would require you to recuse at that point. But the most lenient read of the law would be at least to disclose. Now, in my profession as an architect, we regularly have to disclose. Somebody comes in and they say, oh, we have a lot here, and I say, I have your neighbor's lot. In this case, we've seen a lot of decisions go on in this process without consideration to whether we're legally allowed to do the thing that we are now doing. I certainly was not in the room when you came into contact with this woman from Houston, but we know very well, and it's on the public record, that there is definitely a pecuniary interest between your family and Jim Rogers. So whenever this issue comes up, it should be at least disclosed when it comes up. And for that reason, I feel that you have violated the law in this process, and that from this point forward, you should just simply, if you don't agree with me, then at least go the extra mile and make it clear to the members of the audience, which is not the same people at every school board meeting as I am, what the situation is, what the relationship is, and that when you're steering in another direction, that when you've made a conscious decision to disregard, may I have 2 more minutes, please? Dr. Young, would you offer me 2 more minutes?
Yes.
Thank you. That when you've made a conscious decision to disregard a public petition, that is a decision. And that when you're trying to move forward in attempting to get additional public input that's at odds with the public input, the petition that you've seen already, and there's a fairly clear path from the public not wanting to participate in these other offerings that you're making, that you are in fact leading the public in a direction either away from or to Mr. Rogers, which is the problem, whether you want him or you don't. I personally feel that he would be a good choice, but this is a legal, procedural issue in terms of disclosure, and that one of my primary problems with the board and what they have done in other matters, whether it's on this issue or looking at ADA, is the first question you should be asking yourself is, is what I'm about to do legal? Am I allowed to say this without disclosing beforehand, without recusing beforehand? Thank you.
Stephen Alford.